Good evening and welcome to Preparing for the Post-COVID Legal Landscape, one of several webinars that have been sponsored by Miles Mediation. I'm Sally Akins, and I, along with Roy Paul, Danny Cohen, Owen Murphy, Chris Smith, are some of the mediators located in the Savannah office of Miles Mediation. We're very fortunate enough tonight to have several very experienced lawyers who have a lot of experience in this particular subject matter. And they are as follows: two of our Savannah mediators, Roy Paul. Roy Paul, again, is with the Savannah office of Miles, and he is also a partner with Myers and Sayers in Savannah, where he has over 35 years of experience in commercial litigation, probate litigation, alternative dispute resolution, construction, and personal injury law. Also on our panel tonight is Sarah Lamar. Sarah is a partner with HunterMaclean in Savannah and represents employers in areas such as Title VII, the Age Discrimination in Employment Act, American with Disabilities Act, Family and Medical Leave Act, Fair Labor Standards Act, among others. She also represents employers in breach of contract actions, including non-competes and tort claims, and in agency investigations brought by the U.S. and Georgia Departments of Labor. Last but not least is Chris Smith, better known as Smitty. Smitty is a mediator with the Miles office in Savannah and is also a partner at HunterMaclean. Smitty has over 20 years of litigation experience. He has focused his practice on logistic litigation and commercial law. He is the head of the transportation team at HunterMaclean and a football coach who is very concerned about the impact that post-COVID life will have on his upcoming football season.
Got that right, Sally.
So let me start off by saying that we will, if you look on your bottom panel, you should see a Q&A. And if you feel free during the webinar to enter any questions that you might have for our panelists. And if we have time at the end of the webinar, we'll be happy to see if we can answer some of those questions. We've got some really interesting topics, I think, to discuss tonight in this interesting and difficult time we're facing. And the first thing we thought we'd touch base on is the current COVID situation and the restrictions that the pandemic has put on all of us, our clients, and our profession. I'll start off by just mentioning some of the state bar things that have been ongoing. And the first thing I'd like to do is to give a huge thank you to the current president of the State Bar of Georgia, Daryl Sutton. Daryl has done an incredible job in putting in place lots of different programs and implemented some really excellent ideas in order to help the legal community as well as its clients. One of the most, and to me, the most impressive thing he did was put together a task force that all of y'all should be familiar with and hopefully use if the situation arises. And that is a COVID-19 task force, which is chaired by Paul Painter of Savannah. And what they have done is they've formulated an online form that is available at georgiabar.org. And you simply click on the form and fill out whatever your concern is about whatever's happening in the legal community in terms of when there was an issue about how do we get documents notarized and things like that. It's been very useful for them to be able to identify the problems and find solutions. Once that form is filled out, the committee receives it and someone is assigned in order to respond to that particular request throughout the state. So please, if you needed, use those very good tools. The other thing that is listed on the Georgia Bar website, which is also very important and useful, is if you click on the COVID-19 bar that you'll see as soon as you pull up the website, you'll see all of the Supreme Court orders that have been issued thus far. You'll also see a listing of all the all the governor's orders as well. So those are really good resources that the State Bar has done an excellent job in helping us manage our law practices and continue to help our clients during this time. So one of the things I just mentioned is kind of all the different orders that have gone out around the state. Seems like there's a little bit of difference in how some of the courts are handling things. Roy, I thought I'd ask you first, what's going on as far as you know in terms of Fulton State Court and how are they handling this
And
unique.
if you go on the website, either for Fulton Superior or Fulton State, they refer you to Judge Melton's order and essentially tell everyone that non-essential matters in accordance with his order have been canceled, but then encourage parties and or lawyers with non-essential matters to contact the chambers of the individual judges to see whether anything can be conducted by virtual means. And so there is some indication sort of on a judge by judge basis that to the extent that the parties can arrange for virtual hearing or to move cases in other ways, that that can occur. As we all know, under Justice Melton's order, most things in non-essential cases are stayed. So complaints don't necessarily have to be answered. Discovery does not necessarily have to be answered. And I haven't seen the final order, but it's my understanding from the website, Supreme Court website, that we're going to have the order that currently is due to expire on May 13 be extended for another 30 days. My understanding is that there's going to be some encouragement to have the local courts, the trial courts, to undertake to begin to move things more through virtual methods by having hearings by remote means. And so Superior Court and State Court of Fulton, that's basically where that is. If you go to websites for other courts in the state, most of them that I've seen are referring you back to Justice Melton's guidance. As we know, in Chatham and in State Court and Superior Court here, hearings have been canceled. Hearings are not being rescheduled. Again, I think there is some encouragement to try to do things remotely if the parties can agree to that. But given the stay of deadlines, not much is occurring unless the parties work together and consent to have something moved. So that's sort of generally the lay of the land. I think Smitty can probably address federal court in a little bit greater detail.
Yeah, the federal courts have just had their general guidelines, and we have not received much in the way of what we should be doing as civil attorneys, other than it's business as usual. My personal experience has been that they are willing to give you some discovery extensions, and there's been no guidance as when we may begin jury trials. In my informal conversations with our local state court judges, I think that they are generally in agreement with what all of us heard and what all of us feel like is going to be the way of the things in the near term. And that is, it is unlikely we'll get to any civil jury trials this year, would be my feeling. And talking about it, everyone's floating ideas. For instance, what about in a civil trial if we all consented to using less jurors, 6 jurors, something like that? We could space out voir dire and have less people in the courtroom. But at the end of the day, would that help? Where do they sit in the jury box? How do they go to the deliberation room? Those kind of details just can't seem to be worked out. And, in looking at this issue and talking with other people, we all agree that once we do get juries, the first people to go are criminal trials. And looking at what some other states have done, I have here from Arizona, who's done a pretty good study on this with a plan to try to reopen their court system. They look at number one out of the gate, as soon as a jury is seated, we'll have criminal trials. Obviously, the first ones of those will be where the defendant is in custody. The second one will be felony criminal trials where the defendant is not in custody. The third would be misdemeanor trials where the defendant is not in custody. After those, they move on to juvenile court, mental health, family with children, family without children, probate. We come in at civil trials at number 7, followed only by tax and administrative matters. So the bottom line is, without some consent or other ideas in the short term, it is unlikely we'll get our civil cases heard by a jury anytime soon.
All right, thanks, Smitty. How do you think this is impacting bench trials and arbitration as alternatives to court congestion? I think you're right, Roy, that think that Justice Melton's new order is going to change the current order a bit in terms of encouragement on using other ways to move the cases along so that when we do open back up completely, there won't be a huge backlog.
I understand that the state bar is working on an initiative to try to put together some guidelines for bench trials. So in non-jury matters or in matters where the parties would consent to waive jury trial, if they do have a right to jury trial, perhaps we can move at least towards some bench trials. Absent that, though, other than other mechanisms such as arbitration, perhaps use of special masters, things aren't going to move very quickly, it doesn't sound like.
And Roy, you've done some of this work. How would you foresee a special master playing into an existing case involving a jury trial?
I mean, I think that to the extent that there are pretrial matters, you know, particularly in cases where there's a lot of motions practice or some need for an accounting, those sorts of issues, you know, given the fact that the judges are going to have backlogs and have a lot to attend to, you know, special master may be a mechanism to move some of those pretrial matters forward. It's not going to change to the extent that there's a right to jury trial and that's not waived in some way. It's not going to get you to the finish line, but it might help you get down the road a little bit.
Yeah, from some provisions, it's something I would highly suggest to my clients as a way to move their case forward and try to fast track them under the arbitration rules to get to a decision, because I don't see those happening anytime soon.
Thank y'all. I think probably one of the most pressing things on most people's minds is what is opening back up to business going to look like? And we're fortunate, as I mentioned from the get-go, to have Sarah Lamar with us, who's got a great deal of knowledge and experience in employment-related matters. Sarah, so as the businesses in the state of Georgia reopen and employees are asked to come back to work, what are some of the big issues that you're seeing from the employment perspective?
Well, Sally, one of the biggest things is the unemployment compensation claims that are out there. As Governor Kemp has announced the reopening of most of the economy in Georgia, I hear from my clients, and there's a lot of anecdotal discussion out there, that employees are resisting returning to work. So the business is opening up, folks are excited to maybe make some money again, but their employees say, no thanks, I'd rather stay at home. And there's a couple primary reasons for that. One is that employees may be concerned about their safety, worrying whether the workplace will be safe and hygienic for them to come back to. And those are very legitimate concerns, and hopefully the employer will be able to say, you shouldn't worry about that because these are the litany of things we're doing to make the employment space as safe as possible. And I'll talk a little bit more about that in a second. But there's a whole other group of folks who are not coming back to work because they're making too much money on unemployment. And that may sound cynical, but we have absolutely heard that, especially from certain sectors, perhaps the restaurant, retail sector, hospitality. Right now in Georgia, some people with the federal booster payment of $600 a week are making upwards of $1,000 a week on unemployment. So they're not so interested in coming back. So one of the things that has been coming out is guidance from both the US Department of Labor as it relates to federal unemployment benefits, and then the Georgia Department of Labor as it relates to state unemployment benefits. And the USDOL came out early last month saying, if you quit without good cause, which would include an employer calling you up saying, please come back to work. We have work for you now. And you're saying, no, thanks. I like my $1,000 a week. That would be without good cause. You're not going to get unemployment under those circumstances. Now, there are some exceptions to that. For instance, what would good cause be? What would be a good reason for quitting? And that might be that you're infected with COVID. Of course, no one wants you back if that's the case, or you're with a family member who's infected, or you have to take care of a child whose school has closed. So there are various legitimate reasons not to come back. But the Georgia Department of Labor has also emphasized that if an employee decides to stay home just because of a generalized fear of COVID-19, their eligibility is going to be determined on a case-by-case basis, and they are absolutely not guaranteed to get any benefits. It's worth noting that the Federal CARES Act that got passed on March 27th included an appropriation of $26 million for fraud investigations and audits. So you can bet that some of those will be directed to unemployment compensation fraud.
Sarah, you said that an employee who declines work may lose their unemployment benefits. Are there any exceptions to that?
Well, another exception to that is the Families First Coronavirus Response Act, which applies to employees who, or rather applies to employers who employ less than 500 employees. And the FFCRA, which is one of our alphabet soups of employment law acronyms, basically says if you can't return to work because of 6 enumerated reasons and work is offered to you, then you can get up to 2 weeks of particular leave at full pay, and then 10 weeks of additional leave at 2/3, up to 2/3 pay. So in essence, some of those reasons are you have COVID-19, you think you do, you have the symptoms, you're taking care of someone who does, or your kids' schools are closed. So you get a different amount of money potentially depending on what the reason is. But so when an employer calls up an employee and says, we're ready for you to return, and the employee says, well, my daycare is closed through July, I can't return, that should be a trigger for covered employers not to fire the person, but to put them on the FFCRA leave. So that's just another consideration for those covered employers. When they're trying to get folks back to work, they have to be sensitive to the leave rights under that new statute.
And Sarah, not to put you on the spot, but some of my restaurant clients are wondering what happens if they want you to return to work, but your wages, your tips are simply not going to be what they were before. You're going to be working.
Well, yeah. I mean, that's a really good question, because not only do you have the question of your variable hours, variable rates of a tipped employee in particular, but the one thing I can say about that generally is that partial unemployment benefits may be available to those folks who were brought back, and say they're brought back at halftime. Mm-hmm. So they can still possibly get, in fact, probably get unemployment, at least some unemployment for that period.
I also think safety in the workplace as we all go back to work is important. What's the latest on that?
Well, Sally, there are several areas of concern here. One is from the Osha perspective, another is from the CDC perspective, and then finally from the EEOC perspective. So I'll start with Osha and then go from there. Of course, safety is a huge concern to everyone during this pandemic. I find it very interesting that even though businesses have been allowed to open up as of last Friday. Many of them are being very cautious about bringing all their folks back. And there was an interesting article in the Atlanta Journal-Constitution this week that said some of the biggest companies in Atlanta, like Coke, Home Depot, the Southern Company, Delta, are choosing to have employees who can work remotely continue to work remotely. There is even a reference to Amazon that has announced that it will allow some employees to work remotely until October. Oh. So, of course, some remote employees are productive, and employees can get their job done remotely, but it doesn't fit all workplaces or all workers. I, in particular, do not seem to be nearly as productive at home as I am in the office. So that's why I keep coming into the office during this pandemic. But assuming you're coming into the office, OSHA has issued guidance on preparing workplaces for COVID-19, and it's easily found on the OSHA.gov website. And I'm going to read a few of these, so bear with me, but the advice is extremely broad and is divided into what I would call a risk pyramid. There's very high risk workplaces. Those would be, no-brainer, the healthcare space. And then there's down to the low risk workers, which may be more, a private office space where the public doesn't come, and you have spread out work plan, that type of scenario. So, but the basic requirements are for all workplaces, regardless of the risk. And some of these include developing an infectious disease preparedness and response plan, implementing basic infection prevention measures. And we all know what those words, this sounds fancy, but it's basically hand washing, hand sanitizer, staying home if you're sick, respiratory etiquette. That's a nice way of saying don't cough in someone's face. Discourage use of other people's phones, equipment, computers, keyboards, offices even. Regular housekeeping. There's a whole housekeeping section on the OSHA website about what you ought to be doing to disinfect surfaces, et cetera. Using EPA approved disinfectants for viral pathogens. That's some specific website advice from OSHA. Then creating policies and procedures around identifying and isolating the sick employees, employing social distancing, implementing flexible sick leave policies, and even down to, are you using the high-end, HEPA, high-efficiency air filters for your HVAC units in your offices? Are you putting up sneeze guards? Those, you see those at Publix and Target and other places. Other ideas, staggering shifts of employees. So instead of having everyone come in all at once, and if one person gets sick, you're quarantining your entire workforce for 2 weeks, have staggered shifts, a morning shift and afternoon shift. Some folks are working, couple weeks, other folks are working the other couple weeks of the month. So those are other ideas. Discontinuing non-essential travel, training employees on symptoms of COVID and risk factors, using PPE as necessary. And a lot of people think of PPE as, the respirator. And of course that does apply for certain health workers and workers who are performing aerosol generating procedures. I find that to be kind of a really funny, very general and odd statement. But anyway, but PPE can of course be gloves, it can be masks, it can be other things other than, for instance, the it can be gowns, it could be anything, other things besides just respirators. So those are, I mean, it's a huge list and it's quite detailed, but that's helpful for employers. And really, even if you're a low risk office environment, you should be looking at that OSHA guidance before you bring back folks to work. Of course, if you have a more high risk environment like exposure to bloodborne pathogens or need for respirators, OSHA has pre-existing regulations regarding those issues. And finally, with respect to OSHA, there is what's called the General Duty Clause under OSHA, in which an employer must furnish each worker an employment which is free from, and these are the important words, recognized hazards that cause or likely would cause death or serious physical harm. My understanding is that SARS, West Nile, the bird flu, all were considered recognized hazards by OSHA, and the implication is, or the strong suggestion is, that COVID will be too. So you can't just say these guidelines are, you know, just aspirational and I'm not going to worry about them, because in fact, they could be what is between you and multiple OSHA violations if you looked at the General Duty Clause.
Is OSHA the primary source for safety information for employers?
Well, Sally, I also mentioned the CDC guidance, which is very detailed and keeps evolving. So employers, businesses should keep looking at the CDC guidance. For instance, we're all pretty familiar with the idea that a COVID symptom includes a dry cough, shortness of breath, of a fever, but now it's recognized that a minority, but still a strong number of people are showing different symptoms like nausea, vomiting, diarrhea, etc. So that's now on the CDC website. So it's worth keeping up with this. And you know, the mask requirement wasn't there initially, and now it is there. So the CDC has safety practices for critical infrastructure workers who have had exposure to COVID, for essential workers, as well as for all businesses. So OSHA, CDC cross-reference each other throughout their guidance. So you do want to look at both of those together.
Finally, I suspect everyone wants to know whether they will be sued by their employees who come back to work and get sick. What do you know about that?
Well, and I think Smitty and Roy are probably going to touch on these issues too, but this is just really unfolding. In preparing for this evening's presentation, I looked at lawsuits in Georgia, federal and state, relating to COVID, and what I found was, and I'm not saying I did an exhaustive search, but a lot of lawsuits by inmates who are really pissed off that they may be infected. Similarly, lawsuits by immigrants held in detention, that they are concerned about their safety. At least one lawsuit by voting rights activists that they're not going to get the ballots they think they ought to get because of COVID, delivering the ballots. And I did not find any lawsuits yet by employees suing their employers, but there are some in other parts of the country. And one of those is against Walmart, and that is called, you just find it here. It was Evans versus Walmart, and it's out of the state of Illinois. And there were two employees who sued Walmart or their estates did because they worked there and they passed away from COVID. And they also sued, interestingly, the shopping center in which the Walmart was located. So who's going to bear what responsibility, if at all, for that will be interesting. But what the allegations are, and this is all very new, so that's all we've really got at this point, but that Walmart acted negligently and willfully by not cleaning the store adequately, not enforcing use of masks or other social distancing guidelines, and failing to warn other employees of coworkers and concerns over COVID infection in the workplace, and not implementing a disease response plan or infection prevention measures, which you just heard were what the Osha requirements are asking for. So how they're going to prove causation is deemed by some of the pundits to be a challenge. What's the reasonable care for negligence in this type of scenario? You know, a few people noted there are essential businesses that are, Walmart sells groceries. It's required to stay open, so it couldn't shutter the doors. Everyone's understanding of the virus is still evolving. Governor's orders have changed over time. Certain PPE is not available except to healthcare workers. You can clean your entire workplace, and 1 second later, someone who's asymptomatic comes in and screws it all up. So those are some challenges for plaintiffs in those cases. And I'll just, I don't want to hog the rest of our time here, but I will just mention the workers' comp exclusive remedy issue is also a problem in these cases, that if COVID is deemed an occupational illness or it's covered by workers' comp, then that could be the exclusive remedy. Now, different states have different standards for overcoming that exclusive remedy. Georgia has a pretty strict exclusive remedy doctrine, and it also has a high bar for proving occupational illnesses. So those may make it difficult in Georgia, maybe less so in a state like Illinois. So I'll stop there and let other people talk.
Thank you, Sarah, very much. That's really interesting, and it'll be interesting to see how a lot of that ends up panning out. I guess in addition to the employer and employee side, another thing I'm sure is on everyone's mind, because it's affecting so many people, including many lawyers, is, okay, we've stopped business. You know, I've had to close, or I'm not producing as much revenue as I was before. You know, how is there going to be a way to make that up, right? What's the next step now that I've had these losses? So Smitty, can you tell us that all of our business losses due to the coronavirus are covered by insurance of some sort, please?
Well, some congressmen are pushing that way, but not as of yet, Sally. You know, when we talk about business interruption coverage, I get a lot of phone calls on this. And the first part is to go through your policy and see what different types you have. You know, typically business interruption covers your property, your business losses when you've suffered damages directly to your property, such as your warehouse roof caves in. What the courts look for is physical damage to the property that is caused by a covered peril that results in a quantifiable business loss for a specific duration of time until it's restored. Other types of business interruption insurance include contingent business interruption. And people might not think of this, but you might have coverage for it, wherein it covers when you have a stoppage in your supply chain from someone off premises, from another business that has had to shut down as a result of COVID. And it directly impacts your ability to carry out your manufacture. An example of an event that triggered this was back with the Japanese earthquakes that stopped and shut down US manufacturers' supply chains overnight. Another interesting one that might have Savannah implications is attraction or leader coverage. And that is when you have business interruption coverage for nearby properties that are attractions that attract customers over to your place. A good example of this might be In 2010, there was the Horizon deep water spill, all the beaches down there in the Gulf Coast. People who had a restaurant nearby or a hotel made this type of claim against coverage that the beach attraction that led people to them had been shut down. Now I think that we'll look at restaurants and parks around Disney World, perhaps. What about Tybee Island or downtown Savannah with the squares and the parks? These are areas to be explored under attraction coverage. And lastly, one that will get a lot of attention is civil authority coverage. This is additional coverage you probably have as part of your business interruption coverage. And this applies when an insured is unable to access your property as a result of physical damage to nearby or adjacent property. So your roof doesn't have to cave in, but if the government has closed down the roads accessing your property and there's been physical damage nearby from a hurricane, you might qualify for this type of coverage. All right, so after that, we look at the issues of whether any coverage, has there been this property damage? After Superstorm Sandy, 9/11, those type of things, a lot of the policy language has been tightened up. And they really try to emphasize that property damage is required to get coverage under your civil authority policy.
That's interesting. I wasn't even aware of all those different kinds of coverages, so that's really good information. What do you see as some potential roadblocks to business interruption coverage?
There are two main ones that everyone will be litigating over, and these will be, number one, this requirement that there be a direct physical loss or damage to property. The second one, staring everybody in the face, is if you read your policy, you might be looking at a virus and bacterium exclusion. And that has been put in a lot of policies following the Sars outbreak in a lot of these policies. But if you look at your ISO forms here for your property damage as a triggering event, the ISO form here requires that property damage suspension of business operations must have been caused by loss or damage to the property at your premises. Now, for civil authority coverage to be triggered, you have to have direct physical loss or damage to property other than at your premises. So the threshold question is, does the virus constitute actual property damage? And while we might all agree that the coronavirus is not causing permanent damage to a structure, you know, the health agencies say that it's transmitted from touching. It can be left on surfaces. It can be buildings, airplanes, you name it, arguably damaging the property. I mean, you know, analogy, Sally, if you had a sandwich and I had coronavirus and took a bite of it, you'd probably assert that your property had been damaged and want your money back from Arby's. But, you know, this is a new question for the courts. There is nothing about specifically whether a virus is property damage. So everyone is reaching back and looking at some other cases where courts have looked at some other substances. One case that is getting a lot of attention that's been yanked out of the district courts of New Jersey is the Gregory Packing, excuse me. In that case, there was a release of ammonia that had been released accidentally into a building. And the question is, you know, was the building unsafe until it could be aired out and cleaned? The big takeaway from that case is that obviously the structure wasn't physically damaged. That property could be physically, that could have a loss without experiencing this typical type of structure damage that you would look for in a business interruption claim. Using the same reasoning, a court up in Oregon in the Shakespeare case, they looked at smoke that came into a theater. And important note, this case was later overruled by consent of the parties and vacated. But the court's reasoning throughout it, they looked at the smoke and importantly said that the property was unusable for its intended purpose, that the property had lost its essential functionality. Some other cases in this business interruption line would include Western Fire, and that was gasoline vapors. You've got Matchner v. Seacoast, and that was carbon monoxide. So with these cases, if we were to extend that reasoning to COVID-19, did it make a restaurant unsuitable for its intended purpose?
Is there such thing as a virus exclusion in these policies, Smitty?
Yes, and for every case brought under one of these business interruption clauses, there'll be a very policy-specific analysis that you need to do. As I said, it resulted the SARS outbreak, and I've got the ISO page here. We will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. So you can see that insurance companies will promptly take a look at this and perhaps try to exclude coverage under their policies. But they might also have a coverage. And they also might only insure a certain amount of time under these types of coverage. Something to look at often in these business interruption claims, such as for civil authority, is that they wait 72 hours for trigger, and then they only last for usually about 3 weeks. So you're looking at a finite time of recovery under your business interruption there. But, you know, the insurers will also say that the virus only exists on your property for a very short time, and you can go ahead and disinfect and you're ready to go. Well, the insurers may counter that despite all that, and you guys said this just a second ago, another restaurant guest just came in and brought the virus with him or her. Mm-hmm. And now we need to decontaminate all over again. You know, and then a further wrinkle with, no, you weren't closed for a virus. You were closed purely for a prophylactic measurement by the government to stop the spread of the disease, which will be another fact to look at.
Is there any way around these exclusions for folks?
Well, a lot of people are trying. And one argument that's getting a lot of attention would be the civil authority coverage. Remember, that doesn't require damage at your property specifically. And how the standard language reads that I have right here is that caused by action of civil authority that prohibits access to the described premises due to direct physical loss or damage to the property other than the described premises. So we've got damaged property, Savannah, any of the beaches, any of the restaurant surfaces, you know, that could be described as damaged property. And there's a recent California case that's called French Laundry. I believe it's a restaurant out there that is saying that COVID has infected all of the public spaces around it, staying on the surface for weeks, triggering that civil authority coverage. A number of chefs are using this as the restaurants have been so hard hit and trying to show that with the city orders we've seen, a lot of the governors and mayors are actually writing this into some of their orders to provide that the virus is physically damaging the property. I think Mayor Bottoms of Atlanta cited the extreme likelihood of destruction of property as a result of the virus. But again, even if this works, coverage is still going to be limited, you know, maybe 3 or 4 weeks, depending on the language of your particular policy.
How have insurers been adjusting these claims, if you know?
Well, I've heard stories that they've adjusted them rather quickly, and that has led to some bad faith claims that are out there. There's 2 right now. Big Onion is one of them, and Barbara Lane is another. They're both alleging bad faith against their insurance companies for just a quick blanket denial without any investigation. But the lawyers in Big Onion have come up with a pretty interesting argument. They don't have a virus exclusion in their policy. So their argument is, if there's no virus exclusion in the policy, then obviously a virus could constitute damage to property. If it didn't, why would it be in there? So lawyers are definitely putting their brains to work on this one.
So wrapping it up with you on this topic, Smitty, what's the big picture takeaway on all this?
Oh, and I think there'll be a lot of litigation as businesses are out there fighting for their lives. And behind the scenes, you read about these politicians are really pushing the insurance companies to you know, go beyond their contracts and in some cases and try to insure their constituents. But you know, as an alternative to this sea of litigation, we know that from past catastrophes, some states have tried pilot programs where they've set up mass mediations. Like New York has done this, North Carolina has done this, Florida has done this after large storms, and set up these mediation programs in an effort to address these large-scale catastrophes and insurance claims. And the data reported shows a very high rate of settlement in these claims. So at least that gives us hope.
Great, thank you. All very good tips. Another thing I've been hearing a lot about, probably everyone else has as well, is the force majeure clause. And I guess I'd probably learned about it in law school and maybe heard about it a few times in the last 30 years. But certainly are hearing a lot about it now with respect to how it might impact the COVID-19 issues and contracts and all that stuff. Roy, I think this is probably right up your alley. What is a force majeure clause?
Well, I think the term force majeure is being used generically to refer to a lot of different concepts. I think that force majeure, if you're going to look at that, the first thing you need to focus on is contracts that actually have some form of a force majeure clause. In general terms, a force majeure clause in a contract attempts to address the situation where a contract or a part of the contract can't be performed due to causes that were outside the control of the parties and could not be controlled in some way by the exercise of reasonable diligence. So it's an attempt to look at causes or things which prevent performance that really couldn't be controlled. So that's, in generic terms, what people I think are talking about.
Can you give us some examples of a force majeure contract, a clause in a contract?
Absolutely. In Georgia, surprisingly, there are cases, but there's not a ton of case law out there. I pulled some force majeure clauses out of some reported cases. One is in Camafil Building Inspectors versus Bell South. And that language said, we shall not be held responsible for any delay or failure in performance of any part of this agreement to the extent that such delay or failure is caused by fire, flood, explosion, war, embargo, government requirement, terrorist act, civil or military authority, act of God, or other similar causes beyond our control. There's another case which has a lot of analysis of force majeure and related concepts, which is the Elavon versus Wachovia bank case. In that contract, they had a definition of force majeure and then said that notwithstanding any provision of the rather lengthy contract, no party shall have any liability to any other party hereto for any failure or deficiency in performance of obligations occurring by reason of force majeure. Their definition of force majeure was that it means factors attributable to events reasonably beyond the control of the party obligated to perform, including without limitation, war, armed conflict, acts of terrorism, or other similar events, conditions, or events of nature, civil disturbances, failures of telephone lines and equipment, computer hardware or software failures, or fires. The bottom line is, I think in normal circumstances, when contracts are being negotiated, perhaps not a lot of attention is given to the language in a force majeure clause, and people pull them off their word processor from the last time they had a contract. Now the language of the particular force majeure clause is going to become very important.
How do you think the courts will interpret these clauses?
Well, this is going to be contract analysis. I mean, that's when it's in the contract, you're going to start, at least under Georgia law, with the rules of interpretation, which are in 13.2-2. As we all know, Georgia follows really a three-step process. You look at the language of the contract and try to determine whether there's an ambiguity. I mean, can I tell by simply looking at the language whether it covers what we're talking about, with COVID-19? If there's an ambiguity or some lack of clarity, then the court will move to the second step of the process, which is to look at rules of construction. many of which are outlined in 13.2-2. And it's only then if the court cannot interpret the language of the contract after application of the rules of construction that we have perhaps a jury issue or the use of parole evidence. So that's the process, and we're all going to have to reach back to what we remember from law school, concepts such as justum generis.
Don't be throwing Latin on us,
Heard in
Daryl.
a while, which basically says that when a statute or document enumerates by name several particular things and concludes with a general term of enlargement, the latter term is to be construed as being justum generis, of the same kind of class with the thing specifically named. So if pandemic or epidemic or disease isn't listed, then you're going to get into that sort of interpretation. There are other Latin concepts which you can find in the case law. Non sequitur soci, the words in a document should be understood in relationship to each other, but we're going to go back to using those rules of construction to try to determine whether there's something that can be determined as a matter of law on a motion or whether there's going to be a jury issue.
Are there any other wrinkles or procedural issues in navigating through these clauses?
In Georgia law, I mean, you're going to have a contract that is going to impact you in some way in Georgia. And so if the lawsuit is brought in Georgia, you know, the first thing you have to do is look at the contract carefully. There may be a choice of law provision in the contract saying that the law of some other state is to apply. But Georgia has some twist in that area. For example, Georgia courts distinguish between statutory law and common law. So a Georgia court looking at a contract which is governed by the law of a different state will defer to another state's statutes as well as judicial decisions that construe that statute from the other state. But a Georgia court's going to apply the common law of Georgia. It's not going to look at the common law of the other state. Likewise, choice of law or forum selection clauses may be invalid if enforcement would contravene Georgia public policy. We had some cases under covenants not to compete where you had a covenant which was intended to be governed by the law of a different state, but Georgia would not enforce it. Georgia would say that if another state had law that was different than how we construed covenants not to compete, then Georgia would use its own law and would not apply the law of another state. We don't know how this is going to develop, but there's likely to be litigation over how the laws of other states might be interpreted in cases that find their way to Georgia courts. And all that's going to make it very interesting.
And Roy, haven't the Georgia courts been pretty specific when they look at the four corners and they look at that force majeure clause? I know I was looking at my notes here, the Holder construction case where there was a steel crisis, and the first thing the court said is, this isn't in your force majeure clause. So moving on.
I mean, when you look at the cases, you know, some things have become fairly clear. One, a mere economic downturn is not likely to be construed as any sort of a force majeure. There's an old Georgia case that said even World War II was not something that the parties could not have anticipated and refused to apply force majeure to World War II. So, you know, the courts have generally been reluctant to stretch to enforce those force majeure clauses, but, you know, hard times can make interesting case law. So I don't know how a court is going to construe this on a going forward basis, because there are going to be some stories that are going to be told, you know, that are likely to be heartbreaking. There are going to be business situations where there's a lot of hardship, and there could be some cases that come out of that which might take a different tack.
What about excusing performance outside the context of a specific clause, such
Well,
as
and I think that's the other piece of this, and some people use the generic term force majeure to refer to that, but absent a contract, you still have contract principles such as impossibility that you're going to have to focus on. And again, you start by looking at the Georgia statutes. 1335, says that impossible, immoral, and illegal conditions are void and are binding upon no one. There's been a lot of case law that construes what impossible really means. And frankly, the cases, have, it takes a lot to pass the test for impossibility. One thing that I think you may see is people saying, this has been devastating to me. I can no longer perform. It's had such an ill impact on my business. Georgia law has established pretty clearly, at least up until now, that the fact that one is unable to perform a contract because of his inability to obtain money, whether due to poverty, a financial panic, or a failure of a third party with whom he was relying for financing, that's not usually impossibility. That's not going to excuse performance. And the cases get into an analysis of objective impossibility versus subjective impossibility. I think the truth is, up until now, it's been an uphill fight. Georgia also has 13.4-21, which provides that if performance of the terms of a contract becomes impossible as the result of an act of God, such impossibilities shall excuse non-performance, except where by proper prudence such impossibility might have been avoided by the promisor. And that gets you into act of God, which is another term that probably a lot of us are hearing being thrown around as why I shouldn't or am unable to perform under my contract. Interestingly, there is a definition of act of God in the Georgia Code. 13-3 actually defines act of God, and it means an accident produced by physical causes which are irresistible or inevitable, such as, and that gets you back into justum generis, such as lightning, storms, perils of the sea, earthquakes, inundations, sudden death, or illness. It does say that that definition excludes all idea of human agency, but illness is included in the Georgia definition of act of God. So we're going to have to see whether there's an expanded interpretation of those statutes.
All right, that's great, Roy. I didn't know a lot of that, not surprisingly. We're about out of time, but I just really quickly wanted to throw one to you, Smitty. It seems like the other part of this, dovetailing on what Roy just talked about, is commercial impracticability. You know what I'm trying to say, impracticability.
Yes. Impracticability and frustration of purpose are outgrowths of the impossibility argument Roy was just mentioning. He's covered it all. I just wanted to point out that Georgia has recognized in some older cases that impossibility of performance can occur where the performance has been made illegal. So maybe by analogizing some of those to the civil authorities that you are no longer able to perform, that could be an argument that could be made. And as far as the illnesses go, there is an old Georgia case, the Caruth case, that says it excused performance when an individual was too sick to give notice under a contract. So if you're looking at the realm of personal services, that could be a valid excuse if you are quarantined in a hospital. Now, impracticability, these doctrines are hard to prove. You just have to keep that in mind. And the key word for all of these are going to be foreseeability. That is the most important part, and I think that's where act of God comes in to say this is a surprising event that could not have been anticipated at the time the parties contracted. There is a commercial code definition at 11.2.615 excusing the performance if it's impracticable because of a contingency that goes against the very basic assumptions in the contract, or by compliance with any good faith compliance with any applicable domestic governmental regulation or order. Now, these by virtue of the fact they're in the commercial code, go to contracts for services between companies, contracts for goods, sales of goods between companies, excuse me. But then there's a restatement of contracts, section 264, that provides parties' performance can be excused if made impracticable by domestic regulation or order. So this may be another argument based on these shelter-in-place orders. Frustration of purpose is a closely related doctrine, but the difference to keep in mind there is that performance doesn't have to be made impossible, but the principal purpose of the contract no longer exists. For example, nothing is stopping our favorite band from going over to Driftaway Cafe and playing. Nothing is stopping their performance. But with the coronavirus, did it substantially frustrate the whole purpose of the contract to bring in diners and music? So I think that would be a situation where you could argue for frustration of purpose. I've not found a Georgia case exactly on point. I think that there'll be arguments that sickness and flu are foreseeable, but a government-ordered shutdown of all non-essential businesses could arguably be not.
Great, thank you. Well, Roy, Smitty, Sarah, thank you all so very much for sharing all your very broad expertise with us and the people that were listening tonight. And thanks to everyone who joined us on this webinar. And that's all. Thank you very much. Good night.
Thank you, guys.
Thank you, Sally.